Hello students, welcome to the lecture on Introduction to Business Law, and after this lecture we will be able to learn the following objectives. Define law and society of business, explain branches of law, learning about categories of law, understand meaning and sources of business law, describe businesses, management basics. Let's start with a brief introduction to business law. Business law encompasses the law governing contracts, sales, commercial paper, agency and employment law, business organizations, property and bailments. Other popular areas include insurance, wills and estate planning, and consumer and credit protection. Business law may include issues such as starting, selling, or buying a small business, managing a business, dealing with employees, or dealing with contracts, among others. The Uniform Commercial Code UCC, which governs sales and commercial paper, has been adopted in some form by almost all states. There are agencies at the state and federal level which administer the law in such issues such as employment affairs and consumer and credit protection. The laws aim to protect fair business practices and due process rights for aggrieved workers and others. Businesses interact in many and varied ways. To name just a few types of business transactions, there are contracts, mergers and acquisitions, leasing, etc. How these transactions are carried out is overseen by business law. Additionally, how businesses are formed is a large part of business law. This area of law is very wide-ranging, although it deals primarily with defining the rights and responsibilities of businesses rather than enforcing these laws. Business law is applicable to both small and big. With its broad coverage, several branches of it are categorized to avoid confusion and to promote formality in the process. One of these branches of law is the advertising law. This law ensures that products are being advertised truthfully and to protect the consumers from false promises. Let's now discuss the law and society of business. Law pervades almost every part of human life. Without law, there will be chaos and confusion in society. No games, be it cricket, football or hockey, can be played without rules to govern the players. Traffic rules are important to regulate traffic. Knowledge of law is therefore necessary for all persons who live in a society. Moreover, there is a familiar maxim, ignorantia juris non excusat, ignorance of law is no excuse, defines the word law as the rule made by authority for the proper regulation of a community or society or for correct conduct in life. Hence, law is a set of rules laying down rights and obligations which the state enforces. It includes rules and principles which regulate our relations with other individuals and with the state. Business law. The terms business, commercial and mercantile in relation to law are used in the same sense. Business law is that branch of law which comprises laws concerning trade, industry and commerce. Business law refers to those rules and regulations which govern the formation and execution of business transactions made by various persons in the society. These provisions comprise the legal environment of business. Business law is intended to infuse the much needed certainty in commercial dealings. Business law includes laws relating to contract, sale of goods, negotiable instruments, partnership, organization and many other economic laws having a bearing on trade, industry and commerce. Laws are broken down into several different types. These include constitutions, statutes, common law, administrative regulations and decisions, treaties, ordinances and executive orders. Constitutions. A constitution is the overriding law because it establishes the fundamental principles of a government at either the state or federal level. Statutes and common law. A statute is a law enacted by elected representatives of the legislative branch of government. Administrative regulations are similar to statutes but are enacted by administrative agency instead of elected representatives. Common law, on the other hand, is based on prior court decisions. These laws are applied when cases are not governed by other types of law: treaties, ordinances, and executive orders. Treaties are contracts between two or more political authorities, such as states or countries. An ordinance is a law created by countries and municipalities. Executive orders are laws enacted by the president or governors. The power to create an executive order is granted through legislative delegation. Law classifications. In addition to the different types of law, laws are also categorized into three general classifications: criminal law and civil law, substantive law and procedural law, and public law and private law. It is important to note that the different classifications of law are not mutually exclusive. As noted below, criminal law is also a public law. Types of courts. In addition to defining the various types and classifications of law, the United States legal system also provides different types of courts. The two main classifications of courts are federal and state. Federal courts include federal district courts, specialized federal courts such as the Court of International Trade, and federal courts of appeals. State courts include trial courts and appellate courts. Now moving on to the next topic, we will study the branches of law. Among branches of law, two major fields can be distinguished: private law and public law. The difference between these two branches lies mainly in the parties of the legal relationship in question. Private law signifies rules that regulate the relationships between private individuals, subjects of law who are legally speaking in an equal situation. For example, the legal relationship between a buyer and a seller, where both parties have certain rights and obligations. Private law covers civil law, commercial law, international private law, as well as intellectual property such as copyright, patent law, constitutional law. The characterization of branches of law traditionally begins with constitutional law, which serves as a basis for other branches. Constitutional law regulates in general terms all legal relationships concerned with the state and law separation of powers, essential features of the state legislation. Civil law. Civil law forms the bulk of private law. Estonia's system of civil law is built on the principle of Pandicts, which divides all provisions of the civil law into 5 parts: general part of civil law, family law and property law, law of succession, and law of obligations. The system of Pandicts itself is derived from the law of ancient Rome. Administrative law. Administrative law regulates the activity of public authorities, the procedure of their formation, their powers and relationships with citizens, liability for violating administrative law, etc. Penal law. The penal law dictates which actions are to be regarded as offences and what the punishments for these actions are. In other words, the penal law determines the range of social relationships that stand under protection and the violation of which results in punishment. Procedural law. Procedural law determines the rules of court procedure. Procedural law ensures legal security and precludes arbitrary acts by court. Criminal procedural law is related to penal law. Criminal procedural law regulates the activity of investigation authorities, prosecuting authority, and the court in legislative proceedings in criminal matters. The rules of civil procedural law determine the rights and obligations of judicial bodies and regulate the relationships between litigating parties during the proceedings, as well as the activity of notarial and arbitration bodies, commercial courts that only deal with commercial matters. Let's now know the categories of law. There are various ways of categorizing law, which initially tends to confuse the non-lawyer and the new student of law. What follows will set out these categorizations in their usual dual form, whilst at the same time trying to overcome the confusion inherent in such duality. Common law and civil law. In particular, juxtaposition, these terms are used to distinguish two distinct legal systems and approaches to law. The use of the term common law in context refers to all those legal systems which have adopted the historic English legal system. The usual distinction to be made between the two systems is that the former, the common law system, tends to be case-centered and hence judge-centered, allowing scope for a discretionary, ad hoc, pragmatic approach to the particular problems that appear before the courts, whereas the latter, the civil law system, tends to be a codified body of general abstract principles which control the exercise of judicial discretion.
Common law versus civil law. Now, as I've already talked about, the basic difference within common law and civil law is that within common law there are two effective rules. Do no harm and no threat of harm to another person or property or their property. So if you don't ever do any harm to a man or a woman and you don't take their stuff or damage their stuff, then there really is no law that could be broken. Those are really effectively the only two rules or laws that we need to comply with in order to be living a respectful and honoring life with respect to the people around us. So the ultimate rules of common law apply to freedom, responsibility, and liability. You have the freedom to do anything you want, but you also have to accept the responsibility for your actions, and you also have to accept the liability for them. And we are definitely not trained that we have freedom, and we're definitely not trained to take responsibility, and we're definitely not trained to take liability. Therefore, we're effectively trained to not live in a common law mindset or by action. And the other big thing is there's no need for permission for anything within the common law. You don't need to apply for permits or license because, based on that first note, you've got two rules: do no harm or threat of harm, and you don't need permission to do anything, because if you need permission, it generally means that there's an infringement that you want to do with regards to somebody else's person or property, and you want permission to do that, and that's the only real permission that you'd need. So generally speaking, you don't need permission. You are considered responsible or innocent under the common law. So you are innocent till proven guilty is one of the famous phrases, which means that you are assumed to be acting responsibly until you prove otherwise. And you have the opportunity at the age of 18, 19, 20, 21, depending on your particular jurisdiction, to be considered liable for your actions in common law and responsible for them because you've reached a certain age of maturity where you should know what the right behavior is, and you become responsible and liable for your actions. Up until then, your parents have some legal liability with regards to what you do. So again, generally speaking, that still operates in all common law environments, but we do not normally understand that, and we always act as if we're in the Roman civil law because we do the thing that we really shouldn't do, which is look at all the thousands of laws, which are really acts, legislation, municipal laws that don't apply to a common law man or woman, but only apply to people who step into the Roman civil law and make an application to operate within a particular act which provides limited freedom, limited responsibility, and limited liability. In general terms, all the civil law does is reduce your freedoms and give you the opportunity to reduce your responsibility for your actions and to reduce your liability for your actions, so that you can act in an irresponsible and non-liable fashion, which may be sound like a fun way, but it's really not a good way to operate a society. And we'd be a whole lot better off if people accepted their responsibility and liability for their actions. We'd have a lot less issues and situations. We wouldn't need the laws. We wouldn't need a lot of policing and prisons and so on if people were brought up to think in terms of freedom equals responsibility and liability. So they train us in the Roman civil law by teaching us to be these things and to ask permission for most actions. If you need permission for it, generally speaking, it's a Roman civil law process. And generally speaking, you don't need permission for it to operate within the common law. Now, again, we are trained and punished if we don't get permission, even if we know somewhere deep within us that we really shouldn't need to, but don't know how to apply it and defend it within the common law. We're generally considered irresponsible and guilty within the civil law. Once you're under a particular act with a license or a permit, effectively you're guilty until proven innocent. Now they have to play the game within the court system that it appears that they're treating you as if you're innocent till proven guilty, but if you actually follow the process in courts, you notice that there's a reverse onus most of the time, and you're treated as if you're guilty, and you have to prove your innocence. The whole idea, again, the foundational philosophical basis of the Roman civil law is that people are bad and they need lots of rules to control them. And within the common law, it's the opposite. People are good, and with the proper training and responsibility and liability, people will do the right thing. What type of world do you want to live in? That's the big difference between the common law and the civil law.
Common law and equity. Particular juxtaposition. These terms refer to a particular division within the English legal system. The common law has been romantically and inaccurately described as the law of the common people of England. In fact, the common law emerged as the product of a particular struggle for political power. Prior to the Norman conquest of England in 166, there was no unitary national legal system. The emergence of the common law represented the imposition of such a unitary system under the auspices and control of a centralized power in the form of a sovereign king. In that respect, it represented the assertion and affirmation of that central sovereign power. Traditionally, much play is made about the circuit of judges who travelled around the country, establishing the king's peace, and in so doing, selecting the best local customs and making them the basis of the law of England by means of piecemeal but totally alluristic procedure. The reality of this process was that the judges were asserting the authority of the central state and its legal forms and institutions over the disparate and fragmented state and the legal forms of the earlier feudal period. Hence, the common law was common to all in application, but certainly was not common from all. By the end of the 13th century, the central authority had established its precedence at least partly through the establishment of the common law. Originally, courts had been no more than adjunct of the King's Council, Curia Regis, but gradually the common law courts began to take on a distinct institutional existence in the form of the courts of Exchequer, Common Pleas and King's Bench. Plaintiffs who were unable to gain access to the three common law courts might appeal directly to the sovereign, and such pleas would be passed for consideration and decision to the Lord Chancellor, who acted as the king's conscience. Common law and statute law. This particular conjunction follows on from the immediately preceding section, in that common law here refers to the substantive law and procedural rules that have been created by the judiciary through their decisions in the cases they have heard. Statute law, on the other hand, refers to the law that has been created by Parliament in the form of a legislation. Although there was a significant increase in the statute law in the 20th century, the courts still have an important role to play in creating and operating law generally and in determining the operation of legislation in particular. Private law and public law. There are two different ways of understanding the division between private and public law. At one level, the division relates specifically to actions of the state and its functionaries, vis-a-vis the individual citizen, and the legal manner in which and form of law through which such relationships are regulated, that is public law. One corollary of the divide is that matters located within the private sphere are seen as purely a matter for individuals themselves to regulate without the interference of the state, whose role is limited to the provision of the forum for deciding contentious issues and mechanisms for the enforcement of such decisions. Civil law and criminal law. Civil law is a form of private law and involves the relationships between individual citizens. It is the legal mechanism through which individuals can assert claims against others and have those rights adjudicated and enforced. Criminal law, on the other hand, is an aspect of public law and relates to conduct which the state considers with disapproval and which it seeks to control or eradicate. Although there was strong suspicion and indeed evidence against particular individuals, The CPS declined to press the charges against them on the basis of insufficiency of evidence. When the lawyers of the Lawrence family mounted a private prosecution against the suspects, the action failed for want of sufficient evidence to convict. Meaning and sources of business law. The main sources of business law are English law. Indian business law is modelled on the lines of English mercantile law, as India was under British rule before its independence. The differences in the laws of India and England are primarily on account of their different business, environment, customs and trade practices. The sources of business law in India are generally the English laws, which in turn have their roots in the following. English common law. It refers to a system of law based upon English customs, usages and traditions which were developed over centuries by English courts. These are unwritten or the non-statutory laws. These are found in the reported decisions of the courts of law. Equity. It refers to that branch of English law which was developed separately from the common law. It is based on the principle of fairness and concepts of justice developed by the judges whose decisions became precedents. Judicial decisions or case law. The judicial decisions, usually referred to as precedents, are binding on all courts having jurisdiction lower to that of the court which gave the judgment. This is also called judge-made law. Customs and usages. Customs or usages of a particular trade also guide the courts in deciding disputes arising out of mercantile transactions. Indian statutes. The Constitution of India confers power to enact law on its parliament and legislatures of states. When a bill is passed by the parliament, state legislatures and assented to by the president or governor of a state, it becomes an act or statute. The bulk of Indian mercantile law is statute law. The Indian Contract Act 1872, the Negotiable Instruments Act 1881, the Sale of Goods Act 1930, the Indian Partnership Act 1932, the Companies Act 1956 are instances of the statute law. Business law and managers. Knowledge of relevant aspects of law is necessary for proper functioning of any business. Managers may face a variety of situations that would involve legal issues. Business management basics. Successful business management involves the understanding of organizational behavior and structure. Effective managers demonstrate characteristics of leadership, experience, and overall knowledge of the business community. Familiarity with the basics of operating a business is necessary for organization's growth and expansion as well as for the long-term success of an organization. Managing a business involves staying abreast of the legal concerns of the business community. Legally structuring a business, such as forming a corporation or limited liability organization, protects business owners from the lawsuits and liabilities inherent in the corporate world. Once a business structure has been established, additional legal concerns can affect how an organization operates. Business managers must be mindful of labor and discrimination laws as well as laws concerning compliance issues regarding hiring and managing employees. Employee management. An important part of business management is managing employees. Business managers are often responsible for recruiting, hiring, training, and terminating workers. Employee management involves creating work schedules, delegating assignments, and managing conflict in the workplace. Decision making. Successful business management requires the ability to make good decisions. Business owners are faced with several choices every day. Managers must decide how to effectively discipline employees, when to delegate assignments, and what strategies are best for accomplishing organization goals. Business marketing. Marketing is an important aspect of business planning. Conducting market research in regard to customer demographics, pricing strategies, and advertising allows managers and owners to set realistic organization goals and to forecast a return on organization investments. Business finances. Business owners are responsible for managing most aspects of their organization and finances. Handling the finances of an organization can be overwhelming for business owners who lack the savvy to do it properly. Business managers not only have to consider the tax implications of financial decisions, but also the consequences of borrowing capital or utilizing personal credit for business expenses. There are several resources available for managing business finances, but not all are appropriate for every type of business. Now, in the end, let us summarize what we have learned in this lecture. Business law refers to those rules and regulations which govern the formation and execution of business transactions made by various persons in the society. Civil law forms the bulk of private law. Estonia's system of civil law is built on the principle of pandects, which divides all provisions of the civil law into 5 parts: general part of civil law, family law, property law, law of succession, and law of obligations. Administrative law regulates the activity of public authorities, the procedure of their formation, their powers and relationships with citizens, liability for violating administrative law, etc. The emergence of the common law represented the imposition of such a unitary system under the auspices and control of a centralized power in the form of a sovereign king. In that respect, it represented the assertion and affirmation of that central sovereign power. Contract may be thought of as the classic example of private law, by the extent to which this purely private legal areas has been subjected to the regulation of public law in such areas as consumer protection should not be underestimated. Customs or usages of particular trade also guide the courts in deciding disputes arising out of mercantile transactions.